Good morning, members of the court. My name is Arthur Shartsis. I represent Alameda County, and with the permission of the court, I'd like to briefly go through 5 or 6 items which were responded to and address what the law actually is and what the facts actually are. First, on the issue of direct control, Your Honor, I think you mentioned one of the direct control cases. What direct control or direct regulation or extraterritoriality means under the Constitution is when a jurisdiction issues a regulation that reaches outside of the jurisdiction and causes companies to be required to do things outside of the jurisdiction with their products. A good example is the price affirmation cases. The NCA, another good example, where Nevada's regulation would have required the NC2A to apply Nevada law in all the other states. The cases are clear on this. Healy, Brown-Forman, Baldwin, National Collegiate Athletic Association, Edgar v. Might, they all talk solely about reaching outside of the jurisdiction to require companies to do something outside the jurisdiction. So the argument that this is a direct regulation finds no support in any of the constitutional law of either the Supreme Court or the Ninth Circuit. The second issue that was raised, counsel suggested that the ordinance requires a company to come into the jurisdiction to operate a program. That's right. Actually, under Stipulation 3, which is in Record ER 82 to 87, all of the stipulations, provides 2 things. One is to come into the county to operate. The other is simply to subcontract, to write a check, and by writing a check to cause a recognized stewardship organization to operate within the county. And in that regard, the pharmaceutical industry itself has made the claim that it intends to come in and operate. And while counsel said that would be a $1.4 million a year charge, if the court will simply look at Stipulation 27, you'll see it's a $1.2 million charge, and that it includes the administrative fees of the county, not a very significant number against $1 billion in sales.
Is that the fair comparison, 1.2 or 1.4 versus almost $1 billion in sales? Is that the right comparison?
Yes, Your Honor. And in fact, under S.T. Myers reduces this to cost. S.T. Myers talks about how you measure burden. Burden's not measured by the physical things of what you have to do, that is, hire some people or hire some agency to do work. S.D. Myers at 253 F. 3rd 471 says, while we do not require a dollar estimate of the effect the ordinance will have, the overall effect, we do require specific details as to how the costs of the ordinance burdened interstate commerce. And we have in the stipulations the costs of the ordinance, both Alameda's estimate, which is around $500,000 with the administrative fee, and the estimate of the industry, $1.2 million. That's the cost that must be measured against the benefit. So in one way, Your Honor, you can say, well, this is truly de minimis. It's 1/1000th of the revenue that's received. But the measure has got to be against the benefit. The measure is not against the gross revenue. And so the measure that's required by Pike is for the pharmaceutical industry to come in and prove that that $1+ million burden overwhelms the benefit.
And so what benefit do we measure it against?
The benefit we measure against are the stipulated benefits of health, safety, and environment. And those benefits are the putative benefits, not the actual benefits. The cases are clear. We don't look at the actual benefits, we look at the putative benefits. And if we look again at the stipulations of what the putative benefits are, we're measuring 1/1000th of the revenue generated by the sales against stipulation number 2. The ordinance declares that in Alameda County, the public, particularly children and the elderly, are at significant and unnecessary risk of poisoning due to improper or careless disposal of prescription drugs and the illegal resale of prescription drugs, that the groundwater and drinking water are being contaminated by unwanted, leftover, or expired prescription drugs passing through the wastewater and treatment centers.
But I think counsel acknowledged that in response to one of the very early questions that I asked him, that the county has cited these other concerns, and he's conceded that point.
Well, if he's conceded, Your Honor, then he must prove that $1 million on $1 billion sales substantially outweighs all of the putative benefits that I have just listed.
Let me go over, it seems to me you're still addressing the direct regulation, if you will, of interstate commerce. And I try to emphasize what I thought was the direct regulation, but it seems to me that the plaintiff, even maybe not taking on direct regulation, argues 4 different arguments about that this is direct regulation. And the one that's most worrisome to me is that why should I not apply the Dormant Commerce Clause tax cases to this ordinance?
Well, Your Honor,
Because,
first...
now,
I'm sorry.
just going to say, because it seems to me that all we're doing is we're putting a tax here. We might be doing it a little bit differently, but why shouldn't I just say, I'm going to apply the Dormant Commerce Clause tax or case to this ordinance? And I don't know whether we can really find nexus and fairly apportioned, and so therefore I'm going to throw it out.
Well, Your Honor, first, I would suggest, and recognizing the court has now raised this issue, it's not an issue that even Pharma thinks should be raised. If not, we would have seen it in all the broad briefing Pharma has raised.
Well, I thought Pharma did invite us to apply at Blue Brief 58.
Your Honor, there is one reference to Quill in these briefs, I believe. But given the nature, and I don't want to argue about the briefing, the nature of the briefing, I think it could fairly be said.
I mean, I thought the Gray Brief even at 26, Note 8, talked about it again. That's why I bring it up.
Well, Your Honor, let me cite you to San Juan Telephone Company, San Juan Cellular, 967 F. 2nd, 683. It was the First Circuit. It's an opinion by now Justice Breyer, in which he distinguishes between tax and a fee. And he says the classic tax is imposed by a legislature upon many or all citizens. It raises money contributed to a general fund and spent for the benefit of the entire community. The classic regulatory fee is imposed by an agency on those subject to its regulation. Your Honor, I think this clearly falls as a fee and not a tax. You could provide a tax analysis, but the essence of this issue here is the harm that comes to the county from the selling of the good. And this is an attempt, and I think that Pharma has conceded in its brief that it's not this is not a broadside attack on EPR programs. This is an attack on their direct control argument, but not on EPR. Pharma itself is able to recover its costs in Alameda County if it so chooses. There is nothing that prohibits it from raising its prices and recovering its costs.
Well, but just a minute, I thought that the regulation itself suggests that it can't raise its costs at the point where it enters the county. In other words, it's got to raise the costs for everybody in America, not just the county.
Let me address that, Your Honor. And Pharma conceded this in the briefing below. There is a prohibition on a specific identified fee being charged on the sale. That is, when you get your receipt, you can't say, and 1 cent to cover the cost of EPR, of disposing of the product. There is no prohibition of any kind for Pharma to raise its prices. It's free to raise its prices in Alameda County, and there's nothing that requires it to raise its prices elsewhere. But more importantly, the whole argument of cost recovery really is incorrect, because the Dormant Commerce Clause jurisprudence makes clear that the Commerce Clause is not concerned with profits, it's concerned with fairness. And the best example is Pharma v. Walsh, the case in Maine, where, upheld by the Supreme Court, Maine could require pharmaceutical companies, all of whom were located outside of Maine, to provide rebates to people buying certain drugs. Now, there's no way to recover that cost. You can't raise your price to recover a rebate. So in terms of being burdened with the cost, there was a burden. There is always a burden in any kind of regulatory activity. That's what regulations do. They have burdens. So the existence of the burden isn't the standard. The question is, does the burden outweigh the benefit, Your Honor? Let me go to one point, a few points that were raised to make clear. There was an argument about the Oregon waste case on the de minimis issue, right? That the Constitution, there is no de minimis. Well, the Oregon waste case is a discrimination case, as are the other cases. If you charged 1 penny more for an outside producer as compared to a producer in the jurisdiction, it would be jurisdiction. Those cases flatly don't apply to this question of de minimis. You always have to have a cost in a regulation, and you must always be measuring that cost. It's certainly not a tariff. West Lynn, Your Honor, says a tariff is when you charge people outside the jurisdiction a tax, but you don't charge people inside the jurisdiction a tax. And to lay to rest completely the issue of discrimination entirely, it doesn't matter where these companies are located. They could all be located in the county. They could all be located out of the county. It could be half and half. And the test comes down from Pharma v. Walsh, a very simple and very intelligent test. And Pharma v. Walsh teaches us this concept. If some company outside the county or the state moved into the county or the state, if it could get a better deal, if it could be better situated, then we have discrimination. But we have companies in the county right now. They're treated exactly the same as the counties outside the companies outside the county in terms of this regulation.
What do I do with the council's argument about this ordinance shifts the burden of running the government to out-of-state actors, that it artificially encourages in-state production?
You know, I have trouble understanding the in-state production argument. I just don't understand it. I mean, this is something that's a 1/1000th of the profits that gets burdened on both in-state producers and out-of-state producers. It could only, I guess, promote in-state...
I thought that what he was really saying, it forces us to come in and start a company to try to take care of this problem.
Absolutely not. You just write a check.
Well, his argument then, when I asked him that question, is that would just mean that we're having our agent perform this function. What's your response to that?
Well, under the statute, they can elect to do one of two things. They can either just write a check or they can come in. The law of United States versus Salerno, as cited by S.D. Myers, says a plaintiff making a facial challenge to a local ordinance must meet a high burden of proof and must establish that no set of circumstances exists under which the ordinance would be valid. The fact that the ordinance might operate unconstitutionally under some conceivable set of circumstances is insufficient to render it wholly invalid. So if the argument is having to come in and set up a company makes it invalid, writing a check does not. And I don't believe that having to come in and hire some people to pick up these pharmaceuticals creates a problem because of what I quoted from S.D. Myers earlier. It's all measured by costs. The costs are stipulated too. They're arguing some kind of burden, but in the end, the cost is 1/1000th of their revenue or less, since the revenues probably have gone up since 2010 when we had that number. That's how the measure works. And that's why S.D. Myers talks in terms of cost, because costs are the great equalizer in terms of regulation. Inevitably, for these companies, there's a cost. And the concept of this cost is that these problems are embedded by the manufacturers in the products. They're chemicals. They're embedded by the manufacturers.
Well, they're inherent in the product, is what you're
They
saying.
are.
There's not a culpability factor here.
No,
That has
no,
nothing
no.
to do with it, right? That's not what you intend to be saying.
No. Pharmaceuticals, if properly used, are a good thing.
Yes.
And nobody's going to dispute that. It'd be crazy to dispute that. But the nature of the product itself has embedded in it some problems. The nature of tires, the nature of paint, the nature of mercury-based products, the nature of pesticides, the nature of carpet with those thick backings. There is just a disposal problem embedded in that. And in the United States, as we know from one of the amicus briefs on our side, there are now 70 programs in the United States that say, let's leave the costs with the people who created them. And they will eventually find a way to charge those costs so the contract between the manufacturer and the customer is complete. It covers all the cost of manufacturing, of shipping, of labeling, of advertising, and of disposal. And that really is the future. And that is something that governments, as laboratories, as the Supreme Court, as Justice Brandeis, I believe, said, as laboratories of government are developing. The world's changing. Goods, when we wrote the Constitution, were paper, metal, animal parts, right? Now there are things they could have never dreamed of that are included in products, some dangerous, some not. And government is addressing the problems through this very direct leaving the costs with the manufacturers, and that's all this program is. You elect to sell the product in the county, you take responsibility for the aftermath of what's embedded in the product. It's not going to affect cantaloupes, it's not going to affect tomatoes. There's nothing inherently dangerous about that. There's no health problem, there's no safety problem. A few products are like this, and those products will get measured under the Pike test. Courts like this will look at claims that the regulation of some product is burdensome, and they'll make a decision on it. In this case, it's very clear under the Pike rule, which is the putative benefits overwhelmingly outweigh the burden. Or to put it differently, the plaintiff can't meet the plaintiff's burden here to prove that the burden is so much greater than the putative benefit to the county. That's what this law is. It's the laboratory of local government doing what the Constitution contemplated. And that's what this statute is. I think I have addressed all the issues, I believe. Maybe I should address balkanization, just as the last one. There's nothing here that balkanizes commerce. If Alameda County, if the court upholds the ordinance, Alameda goes forward, promulgates this ordinance. No state or county, not Los Angeles, not Nevada, not Idaho, none of those places are going to retaliate against Alameda County. They're not going to put up barriers to Alameda County. They're not going to make it harder for Alameda County businesses to do business in Idaho or South Dakota or Alaska. That's what balkanization is. What the Commerce Clause did was try to unify the Union. It was essential to the Constitution. It was a failure of the Continental Congress. So when they wrote the Constitution, they wanted to be sure there weren't barriers between the states. So one state that sold tobacco couldn't keep another state's tobacco from being sold there. That's what the Commerce Clause does. This does not violate the Commerce Clause in any possible way. It's not extraterritorial. It's not control of commerce outside of the borders of Alameda County. It certainly is not discriminatory, and it leaves us only with the Pike balancing test. And there I would submit that the pharmaceutical industry has completely failed to show how the de minimis burden, the 1 cent or $1 and $1,000 charge, outweighs the putative benefits of the case.
I have a question, and I realize there's a severability clause in the ordinance that was passed, but there's a provision that kiosks specifically targeting controlled substances must be provided if a county law enforcement agency agrees to provide space for such kiosks, 653.050A11, and then there's another provision that deals with that too. And it seems like that is a police function, and if you talk about controlled substances, leftover things from a meth lab or something like that, that isn't something that the pharmaceutical...
That's not what we're talking about here. This is pharmaceutical goods sold at pharmacies that are bought by individuals. That's the focus. Right now I can tell you that the police stations in Alameda County actually collect hazardous materials. And so people can drop off things there. There's a separate program which deals with hospitals. That's in place. This is really the consumer side of all of that.
Mm-hmm. All right.
So there are different ways these things are dealt with, but this is something that's lacking in the county and that needs to be done.
Opposing counsel's position is in the briefing. They say repeatedly that it's not lacking in the county. It's just that they're wanting. This is a cost-shifting measure. Do you want to respond to that? Sure,
Your Honor. There's no evidence that the county is doing this program. This is an expansive program, and in fact, the pharmaceutical companies have to submit a program which is approved under the regulations. So to say the county's already doing it, we don't even know what the final program will be. But the county doesn't do it. There are a number of kiosks that are maintained by the county, and I can advise the court that, and there's a reference to 28 of them. 4 of them are run by Alameda County. The rest are run on a voluntary basis by others, but not the county. So that program doesn't exist.
Thank you.
Thank you for your argument, Counselor.
Thank you, Your Honor.
We'll hear again from you, Mr. Carvin.
May I briefly make 4 points? In terms of